Hi, everybody. Welcome to our monthly webinar on compliance. Thanks for joining us today for our deep dive into employment verifications. My name is Leah Kelly. I'm here with Shannon Wheeler, our general counsel.
Hi, everyone.
We host this webinar every month to give you a better sense of the different topics within compliance, let you know of any changes on the horizon, and show you what Tenstreet can do to help keep you compliant. So you know, this webinar will be recorded and sent to you within the next 24 hours, so just hold tight. It will be here probably tomorrow around the same time in your inbox. Also, feel free to submit your questions anytime throughout the webinar. You can do this by using the text box in your GoToWebinar panel, and we'll try to get to those as you write them, as you ask them. But if we aren't able to, for whatever reason, we will definitely get to them at the end of the webinar as time permits. And that is, Shannon's going to get us started actually with the funnest slide in the deck.
The legal disclaimer, as always, if you've been attending these, you know that we give these at the beginning of all of our compliance webinars, and that's because the information that we're giving on this webinar is educational information only and does not constitute legal advice. While I am an attorney for Tenstreet, and I cannot represent you or give you specific advice as it relates to you or your needs. So we recommend that you consult with qualified legal counsel on all of the issues, laws, and regulations that we talk about on this webinar. And then Tenstreet expressly disclaims any warranties associated with this presentation or the information provided herein.
Okay. So as I said, today we're going to take a deep dive into employment verifications. We'll spend this time walking you through how you can properly conduct an investigation into driver safety performance history, otherwise known as the employment verification process. And then she'll lead then by talking through what you need to do step by step to request and provide verifications. She'll discuss DOT regulations. We'll go through some best practices, talk about drivers' rights for whenever they want to request information or whenever they want to refute it. And then we will, that's it. So let's go ahead and then we'll get to your questions too, the ones that we don't get to as we're going through it. Okay.
Sounds good. Yeah. Okay, so this is just a really broad overview of what are we talking about when we talk about employment verifications. That's the term that is used most common in the industry, but what it really means, as stated in the regulations, is an investigation into the driver's safety performance history. So you can find this at 49 CFR section 391.23 of the Federal Motor Carrier Safety Regulations. So that is where that's the regulations that talk about employment verifications, and what they refer to is that each motor carrier shall make the following investigation and inquiries with respect to each driver it employs. And then section 2 says an investigation of the driver's safety performance history with the Department of Transportation regulated employers during the preceding 3 years. So even though the industry as a whole refers to it as employment verification, what we're really talking about in the DOT world when we're talking about employment verifications is an investigation into the driver's safety performance history. And so what that encompasses are the minimum requirements set out in that regulation, 391.23. This is what the DOT requires. You can ask for more, you can get more, but you have to comply with these minimum efforts. And that's what we're going to cover today and offer you some just best practices on these things. Okay, so big picture, what do these require? What does this regulation require? It requires that you have make a good faith effort to contact all previous employers within the previous 3 years and investigate these 3 things: general employment verification, accident history, and alcohol and controlled substance history. And we're going to go through each of these requirements in detail since this is our deep dive. Okay, and Leah put together this awesome slide which walks you through step-by-step, big picture of how do we conduct this investigation? How do we do these employment verifications? What is involved in this investigation? I'm sure these are all questions you have, or you want to make sure that you're doing all the things that you're required to do. And so here's a big picture slide of all the things that the regulations require. get authorization from the driver, gather a list of the employers, contact them, keep documentation in a driver investigation history file, request the general employment information, the accident history, and the drug and alcohol information, and then respond to each verification of employment that you receive within 30 days, and make sure you notify drivers of their rights. So let's dig in and go through these things. All right, step 1, you'll want to get authorization from the driver. Section 391.23F says you must provide the prior employer the driver's consent for release of the drug and alcohol info. If a driver refuses to grant that consent, then you cannot permit the driver to operate a commercial motor vehicle. So the best practice is also to get the authorization for release of the employment information and the accident data as well. Oftentimes, the prior employer is not going to give you anything unless you have a release from the driver. The best place to get this release is in connection with the application. So after they sign the application, also present them with a page that gets the drug and alcohol release and a release for the employment data and the accident data. So you might be saying, what is this section 40.321 release for drug and alcohol? What does that say? What's required on that? I thought I'd just go ahead and include that on this slide too. So you have to get this release because that portion of the regulations prohibit releasing test results without the employee's specific written consent. So you have to get a release with the signature of the applicant on it, and it must identify the specific name of the company that is authorized to receive the information. So it cannot be a blanket release. You're going to want to get a list of the previous employers that you're going to request this information from, and you're going to want to put that information in the release and have the driver specifically sign off on that drug and alcohol release with the specific names of the company, and then you'll have it so that you can get that drug and alcohol information as well as the employment and accident data. All right, then you're going to want to gather a list of the previous employers. You might wonder, how do I do that? Well, the application for employment is a great place to start. Section 391.21 of the regulations cover the application for employment, which requires that you get at least 3 years of the applicant's prior employment. If the applicant has operated a commercial motor vehicle for the last 10 years, it requests you have to request that you get 10 years of prior CMV experience. So other ways to find out prior employers are look for gaps in employment. If they've listed several employers, but the dates have a year-long gap in the middle of it or a 6-month gap, it's very likely that that driver was driving during that time period and just didn't identify that employer. And so look for that gap, go back to the driver, ask them what they were doing, say, hey, were you working in this time period? Who was it for? You can also, there are lots of companies out there, including if you use Xchange, that you can do a database search for prior employers for those drivers using the driver's social security number. So again, you're going to have certain paperwork and documentation to be able to go look for that, do those database searches and look for those gaps in employment. Make sure you have all those employment histories. But those are places to start in getting a list of all the prior employers.
Okay, and we have a question here. So they're asking if they can hold off on requesting this info until after they hire the driver, or do they need to do it beforehand?
Yes, that's a great question. And it really is going to depend on your company process. The regulations require that you do this within the first 30 days of employment. They don't require that you do it prior to employment. They require that you have and gather this information and do this investigation within the first 30 days. However, I think most carriers that we come into contact with do this simultaneously in processing the application prior to hire. Sometimes they'll do a conditional offer of employment and then do this information. Sometimes they put them in the truck and they just get it within that first 30 days. However, you'll learn a lot of information about the driver through this process. So you might learn within that 30 days that this isn't somebody that you really want out driving one of your trucks. So it really is just going to depend on your company process, your company, procedures and how they require you to do this. But the regulations say within the first 30 days.
Okay.
All right. So after you've gathered your list of prior employers, you want to go ahead and contact them. The regulations say that the investigation can consist of personal interviews, telephone interviews, letters, or any other method for investigating that the carrier deems appropriate. So ways that we see and that have been deemed appropriate are by fax, by email, by telephone call, by letter. Also, our Xchange product is exactly what this process is. It's requesting the employment verifications from the prior employer, and the prior employer provides it through Xchange. So essentially, it's just an investigation, and by any means that you deem appropriate to get this information. However, one other thing that you have to do is you have to give the specific contact information where the prior motor carrier should send the information requested. So you have to actually put that in the request. If you use Xchange, it's already in there. If you do it by fax or email directly to the prior carrier, you're going to want to make sure you have contact information so that the previous employer can send the information back to you, whether that's your fax number, your email, telephone number, or via Xchange. You want to make sure you have that. It's required by the regulations.
We do have another one that came in. Why do signed releases expire after 30 days? Is there a reason that you know of that would explain that in a protocol or practice?
So I'm not really sure if the question is asking about drug and alcohol releases or a release for consumer report. I'm just not really sure what the detail on the question is. So I think the best thing to do there would either be to contact your attorney, or if you want to send us a detailed email, I can see if that is specifically identifying what release you're talking about. I might be able to dig into that a little bit more. Oh, you are talking about drug and alcohol? Drug and alcohol release. It might be in the regulations. Let me look. I have the regulations pulled up in front of me, and I haven't specifically looked at a requirement for them to expire in 30 days. It might be in the regulations. I'm just not 100% certain on that.
Okay.
So I can look into that and let you know. All right.
Okay. Yeah, and so some people are writing and asking what this database is here on this slide. I just went back one slide really quickly for the database searches for prior employers. This is talking about our Xchange product, which we'll get into here momentarily. And we'll tell you all about how that works too. So bear with us. Now, where'd my mouse go? There it is. Okay, here we go.
All right, so the regulations require that you keep documentation they specifically say each motor carrier must make a written record of the following. So you want to keep a record of each previous employer that you contact, or document your good faith efforts to contact them. You want to keep a record of the employer's name, address, the date they were contacted, or the number of attempts made and the date the attempts were made. You want to keep a record of the information received about the driver. And then if for some reason there was a failure to contact a previous employer or a failure of the prior employer to provide the information, you want to keep a record of that. And so then the regulations require that this documentation be placed in the driver's investigation history file within 30 days of the date the driver's employment begins. So that was answering that earlier question. So you want to conduct this investigation and put this documentation within the first 30 days. And we're getting ready to talk about what a driver investigation history file is. So Section 391.53 covers a driver's investigation history file. And what it says is that this history file must be in a secure location with controlled access. It can only be used for hiring, and it can only be seen by those involved in the hiring decision and insurers. So oftentimes your insurers of your motor vehicles and your drivers want to see this information. However, please note that insurers cannot see alcohol and controlled substance data. They can only see the accident data, which is probably what they're most interested in, and that, you know, all previous employments and dates of employment have been covered. You also need to have the driver's signed drug and alcohol release in this driver investigation history file. And then you need to keep all responses received in the investigation that you're conducting or the documented good faith efforts. And then you need to keep this driver investigation history file as long as the driver is employed plus 3 years. So that is the driver investigation history file that you're going to want to put all of these employment verifications in.
Okay, and then so a question about this. If there are employers missing that are past the 3-year requirement period, do you need to go back and do the due diligence of collecting whatever's missing and put it back in the file, even though it's past the 3 years if it has expired? It doesn't say whether these are.
So I would say that there's what's required by the DOT, and then there's what's a good practice. What's required by the DOT is that you have this information, this investigation conducted for all employers for the previous 3 years. And so you can do more. So you can go back and get for the previous 5 years, for the previous 7 years. It's really up to your company policy and what your company wants. There's nothing that says you can't get more. But what the regulations say is that you do have to have at least 3 years of prior experience. Does that answer the question, you think?
Yeah.
Okay.
Yeah.
Great.
Okay. Keep on going.
All right. So what do you need to request? What are the specifics? Well, the regulations say, first off, general driver identification and employment verification information. So what that means is however you want to interpret it. But good things that we suggest are the name and address of the prior employer, as well as the name, address, and date of birth of the applicant and employee, the position held, the period of service, so those would be the dates of employment, any reason for leaving, the driver type, which would be the type of CDL they have, if they were subject to the FMCSRs, if they were in a safety-sensitive function, the area that they were driving, the equipment that they were driving, regular miles or loads that they carried. These are all things that you can ask for. Now, this is where it gets a little bit subject to interpretation, and that is what do you have to provide? The regulations say that you just have to provide the minimum of what's required under the regulations. And so since the language in the regulations is just general driver identification and employment verification information, this certainly is not a list of things that you must provide or things that you must request. This is just suggestions that we have that are good things to find out. But I would say what would absolutely be required would be the name and address of the prior employer, the identification of the applicant or the employee, and the period of service. Those things would probably be required under the DOT regs. However, this is sort of a gray area in the regulations of what specifically is required to be provided and requested. So keep in mind that the regulations are a minimum, you can always request more.
And if they've never had a driving position before, and this is, they're a student driver, or else, they're brand new to working in DOT, working with a DOT company, what kinds of information should they keep in their DQ app? Does it still have to go back 3 years? And
yes. Okay. Yes, you do still want to go back 3 years to try and get as much as you can, and just get what information you can. Maybe what the position held was. So if they were a cook at KFC, then you would want to list KFC, name and address of the employer, confirm the address of the applicant and the employee, as well as the position held and the dates that they were employed there. You would want to get as much information as you can. If it is a commercial motor vehicle job, though, probably be a best practice to get more information, but certainly a gray area on what is required.
Okay, thank you.
All right, the next thing that you want to request is the accident history. What the regulations say is that you must provide the accident history specified in Section 390.15. Section 390.15B So what that is that's the accident register. That's the regulation that requires that you keep a list of all the following information about an accident. This is the same information that you would want to request from the prior employer in the employment verification stage. So the date of the accident, location of the accident, the number of injuries, if any, the number of fatalities, if any hazardous materials that were released or involved, any copies of accident reports. Again, this is the minimum amount of information. If you wish to provide more, or if your company has a policy about providing more, you are certainly welcome to provide more information so that the employer can have this information to look at and evaluate. We get a lot of questions about what is an accident, and so I went ahead and included that on this slide. An accident is actually defined by the regulations. If you look at section 390.5, accident is defined as an occurrence involving a commercial motor vehicle which results in a fatality, bodily injury, or disabling damage requiring any vehicle be transported away by a tow truck. If you're really curious about what constitutes an accident, go look at section 390.5. Again, a little bit of a gray area here. So,
okay.
All right, and then the next thing that you must do in the investigation is seek an investigation on the driver's previous alcohol and controlled substances, and if there were any violations under the FMCSR section 382 Part B. So 382 subpart B covers essentially all the prohibitions or the violations for alcohol and controlled substances. So things like an alcohol, if the driver's ever been had an alcohol test that's registered 0.04 or higher, ever had a verified positive drug test, ever had a refusal to test, excuse me, those are things you're going to want to seek, that you're going to want to request as well as provide. Also, if the driver has ever had a failure to undertake or complete any sort of rehab program at the recommendation of the company, you're going to want to request that. And then if they have completed a rehab program, but then there were any subsequent violations or refusals, you're going to want to report that. And remember, again, these are the minimum requirements. You can request more, but when you're providing, on the providing side, you're going to want to provide these as well.
Okay. And then back on the previous slide, a couple questions about non-DOT reportable accidents. Do they need to report those as well if they don't fall under the definition of this accident?
You are not required to report anything that does not fall under the definition of an accident in the regulations. However, you can if you wish, and the regulations specifically allow that the previous employer provide additional information if they wish to provide additional information. So this specifically sets out the minimum requirements. However, non-DOT reportable accidents are commonly reported. We see that a lot, and it's certainly allowed under the regulations to provide more because it's good information for companies to know.
Yep, it's good policy. Okay.
Okay, so we have so far covered the requesting side and what the employer might want to do on the investigation, but what about responding? Section 391.23G specifically sets out that previous employers must respond to requests with the DOT defined information in the regulations. So we get these questions a lot, do I have to provide? Yes, the regulations do say that you have to provide. What do I have to provide? You have to provide the DOT minimum required defined information that we have covered. And so you also, Section G also says that you have to ensure the accuracy of the records. So you're going to want to make sure that they're not erroneously reporting false information. You want to provide specific contact information so that a driver can contact you if they have any correction or rebuttal of the data that is specifically required in the regulations. You want to keep a record of each request that you've received and each response that you've given for at least 1 year. That includes the date, the party to whom it was released, and a summary of what was provided. You want to take all precautions reasonably necessary to protect the driver's safety performance history information from disclosure to any person not directly involved. So this is sort of this is the regulations communicating that you have this obligation to keep it confidential and not provide this information to just anybody and everybody who can see it. Just only the people who are requesting it, only the people who are necessary to be involved in it. And then you have to provide it using a method that reasonably ensures confidentiality. And that's sort of a gray area. However, fax, email, telephone call, or other similar form are set out in the regulations as something that you can do confidentially. You can also provide using Xchange, and all the information is conveyed in a confidential manner and is secure within Tenstreet's Xchange network. So you might wonder, what do I do if there is no history for that driver? If we don't have anything, you're still required to send a response confirming the non-existence of such data.
We just got a question like that, so good. Perfect timing. Okay.
All right, so the regulations, section I, 391.23I, specifically require that you, the prospective employer, notify drivers of the following rights. So these are really good things to put in your release information. And so you're notifying them of your rights, and you're notifying them and getting their authorization to obtain this employment history, the accident history, and the drug and alcohol history. This is a good thing to throw in there as well, and just give them a notification of their rights. And that is the right to review information provided by previous employers, the right to have errors corrected by the previous employer, and for that previous employer to resend corrected information to the prospective employer. They have a right to a rebuttal statement attached to any information that's not corrected if the previous employer and the driver cannot agree on the accuracy of the information. So those are the three things you need to provide for them. Good. Okay. So what happens when a driver requests the information, and how do they do that? Drivers who want to see what previous employers have provided about them can submit a request to the prospective employer. Say, hey, I want to see what these employers provided. That can be done at any point in time. And then the prospective employer must provide that information to the applicant. And you have 5 days, and it's either 5 days from the request from the driver, or it's 5 days from when the prospective employer receives the information from the prior employer. So if the driver requests the information, but you don't receive it from the prior employer for 10 days, just 5 days from when you receive the information, you need to provide it to the driver. Or if you already have the information and the driver requests it, you need to get it to them pretty quickly. So 5 business days is not a whole lot of time. As soon as that driver requests it, you want to be on it, note your deadline on your calendar, and make sure you get that out to the drivers. Okay, so what happens about when there's rebuttals? A driver must send the rebuttal to or request correction of the information directly with the previous employer. And so the driver goes to the previous employer. What happens then? Within 5 days of receiving a rebuttal, the previous employer has to do one of two things. They have to either correct the information, or they have to notify the driver within 15 days of receiving the request that they don't agree to correct it. Because you believe it's accurate, and then they can add a rebuttal to the information. So if you correct the erroneous information, you need to forward the corrected information to the prospective motor carrier that the information was provided. So you use Xchange. Any corrections automatically go out to the prior requests for the last 30 days. If you don't use Xchange, you're going to want to make sure you send the corrected information. If you attach the driver's rebuttal to the information, it should be included in any subsequent requests for 3 years going forward. So any requests that you get for verifications of employment after that, after you receive a rebuttal, needs to stay with the driver's record and go out for the next 3 years. If you use Xchange, we do that.
Okay, and there's a question here. For these rebuttals and for the request for information, does it need to be a written request from the driver, or is it just, can they walk in and say it, or what is the recommendation?
I do believe
the regulation.
I do believe the regulations say a written request. However, I think it would be a best practice to just, if you verify the driver is who they say they are, you might know that it's them, but if you aren't sure it's them because you've never seen them or encountered them, but verify that they are who they are. You want to verify their identity. If they walk in and they want to rebut the information, I wouldn't be too big of sticklers on making sure it's a written request. However, I do think the regulations say written request. So,
okay.
All right, and so the regulations actually in Section L have this legal protection. If you have followed the letter of the law and complied with all of the procedures in the regulation, then the regulations say that no action for defamation, invasion of privacy, or interference with a contract based on the furnishing or use of the safety performance history information can be used against a carrier investigating the information or a person who has provided such information. So if you're following the regulations and you're not knowingly furnishing false information, then you will have legal protection under the regulations. That's the good news.
Good. Okay, so we've dropped a few hints about Xchange. We've mentioned it a few times on this webinar, and so just to cover it, we like to keep these webinars primarily educational, but just so that you know, there is a really great solution out here that if you are not using the Xchange system, it's our employment verification platform. It's actually one of our biggest network effects here at Tenstreet that just continues to grow more powerful as new companies are being added every day. It's the largest verification system in the industry. We cover over 40% of today's requests and responses. So it's handled by Xchange. That equates to about 50,000 different companies, DOT and non-DOT both. This means that all their contact information and their preferred method of contact is already stored here for you, and it populates whenever your driver application, it populates with your driver application data. So you have information about the dates of service and things like that. So it just simplifies, essentially eliminates the traditional time-intensive process. So Xchange is very, very simply put, a digital faxing system that makes verifying and providing employment verifications, drug and alcohol, accident reports just simple and fast, so you can say goodbye to your fax machine. And it uses some built-in automation and workflow to track all your good faith attempts for you, and it automatically detects gaps in employment, which, as you remember, are just two of the minimum requirements from Part 391.23. And then it summarizes all your activities and all of your activity and results in a centralized location for all your driver's investigation history files to live, which it creates for you, so you can finally put manual faxing to rest. So finally, this kind of digital organization makes driver requests for information rebuttals easy. It helps you keep track of requests so you can answer them within the 30-day period. And then Xchange even streamlines the submission of termination records to HireRight and DAC for EHF credit for those of you who do that. So overall, it accelerates the whole investigation process that Shannon has talked about today. I've included a cut sheet also. There's a little quote here on the side too from one of our clients. You want to read that? But I've also included a cut sheet on Xchange that you can find in your documents on the side of your GoToWebinar panel under the files, as well as a PDF version of this presentation that you can download too. So there's 2 files in there. And I'm going to also include a link to the demo of our Xchange. If somebody ever wants to take a little bit of a deeper dive and see exactly how that works, we do refreshers every month, and there's a demonstration out there that we can give you so you can, at your leisure, take some time to see how it works.
And I just want to say that when Tenstreet put together Xchange, they really built the program to work around the regulations and to work in compliance with the regulations, so that if you're using Xchange and you're using it properly, you would be in compliance. So We have a whole lot of heartache here about saying whether you are or are not in compliance, but certainly if you use Xchange, you're well on your way to meeting those requirements of the regulations. All the information is secure, and it's just a really great, easy way for both requesters and providers to come together under this network to be able to exchange this information that's needed in the investigation and that the regulations require. And like Leah said, we do webinars every month on Xchange so that you can dig in and see how that works, and then she's going to post a link.
And I just did. Okay, so let's go back to our questions and see what we can pull up here. We had a few I know that I did pass over, and some that I answered just independently. But if you have a previous employer that says there were no accidents, but the MVR of the driver states differently, and you contact the company, but the company refuses to release the information, what do you do?
That's a really good question, and that's a really detailed, factual situation. So I really can't give you any advice on that one. I think you're just going to need to either talk with your attorney or just do what the best practice is to dig in and sort of further investigate that issue.
Okay. And let's see.
While Leah's looking through the questions that you all have submitted, just wanted to give a little plug. If you're not already signed up for our user conference, I will be at the user conference giving a chat on compliance. So there's a lot of benefits to going. We're going to have a lot of things about Tenstreet, a lot of things about using our products and using our system, a lot of good information, and a little bit about compliance as well. It's going to be a lot of fun in Vegas.
That's right. Okay.
All right. Well, if you guys have any questions that we haven't answered, feel free to write in or email Leah.
Yeah, let's do it that way because I know we answered a lot of them, and some of them are a lot of just corner case questions, which we can't really get into, that you might want to have to talk to one of your lawyers about. But let's ask any questions that we didn't get into or didn't cover online. Just let's write into, you can write them into me at leah@tenstreet.com. That's LEAH. And then I can get you an answer that way. And don't forget to download your files. Also, if you want to know, if you have any ideas for next month's deep dive or any of our, future compliance webinars, if you want to learn more about something, definitely write in and let us know. And we want to just really thank you guys for joining us today. We really value your time and appreciate you being with us, and hope you have a great weekend.
Great. Thank you all.
Thanks a lot. Bye-bye.